requirements for a judge of the Court of Appeal.
Mm-hmm.
Yeah.
So how do you bring your experience to bear?
In terms of the competency, because a judge, of course, must be competent, it's that...
Please speak to the mic.
Sorry. Thank you. Now, in terms of the competency, is that I'm qualified. I have master's from Mount Kenya University in Governance and Ethics. I have LLB, a diploma of law in the Kenya School of Law. I have now slightly over 30 years, both in private and in the bench, and that is in public service. Prior to joining the bench, which is almost 11 years ago, I was in private practice. I practiced for almost 19 years. In those 19 years, I occupied leadership positions in LSK. And that kind of prepared me and enabled me to have interactions or engagements with the judiciary and other court users. So I would say that when I joined the bench, which is over 11 years ago, I have continued working. I have, of course, honed my skills. Before I joined the bench, of course, I didn't know what it takes. I knew that sometimes a judge must have a calling, must have passion for the job. But I had little information of what it really takes. It takes a lot more. You need to be a person of impeccable character, impeccable integrity, if you have to serve and inspire public confidence to the people who come for justice in our courts. So I believe that with the experience I have got in writing my judgments, analyzing my cases before me, I believe I fit the appeal to come to this court because I have the energy, I have the commitment, I have the passion, and in my years of delivering or dispensing justice in the High Court, I believe I have exhibited that with exemplary performance, as indicated in the PMMU that has been happening in the judiciary. If you will allow me, CJ, I will go on and say what I have achieved.
That will come in the detailed interview.
Thank you, CJ.
Yes, thank you very much. But just before we go to that, I've seen your master's degree is on governance and ethics.
Yes.
Which is quite appropriate.
Yes.
So maybe you can tell us what are the trends that you have observed that exacerbate the problem of corruption in the judiciary, and what do you think can be done for this existential threat to the country and to the judiciary?
Yeah, thank you for that question. That's a good question, CJ. This issue of corruption is about perception. It's about what Wanjiku or those litigants and advocates encounter every day they are in court. Sometimes most of us have lived to that calling, to that standard or expected of a judicial officer or a judge. Unfortunately, there are situations where we have not been able to live up to that. And I believe that there are mechanisms which should be able to check those few cases of corruption in our judiciary. We have started in our own way in our stations. We've started collecting complaints from members of the public through suggestion box. We usually have meetings with stakeholders, with the advocates, and usually when you engage them in a free and open way, in a confidential manner, they are able to share information regarding the happenings in the courts that we work. And when you get that information, you act on it. Personally, I have been very forthright in ensuring that there is no acts of corruption where I serve or where I preside.
Did you establish the integrity committee in your station?
That's a good one. Luckily, the station, my current station, that is Kitale High Court, I went there and found already my predecessor, who is none other than a commissioner now here, had already started. So mine was simply to sustain the same and ensure that the same was actually working. I went there and I realized that some of the members were not active, like people from the Anti-Corruption Authority. So I called them and I told them that this judiciary is ours. This Kenya is ours. We must do something at our level.
Well done.
Thank you.
So I'll hand you over to Justice Ishare to carry on the interview.
Thank you, Honorable Chief Justice. Judge, I'd like us just for the purposes of this morning interview to focus on one piece of legislation, and this is the Government Proceedings Act. You know about it?
Yes, my lady, Commissioner, I know about the Government Proceedings Act. It's Section 13.
No, please wait. So the Government Proceedings Act, Section 21, speaks of execution when it comes to government property, and Section 13A makes it mandatory that before you file suit against the government, you must give 30 days notice. This matter was subject of litigation before one of the judges of the High Court, and we can speak about it because it has now been fully determined, and the judge did come to the conclusion that by having these provisions in the statute, one offers the government preferential treatment as a litigant, and two, that it is a colonial relic. So because this matter was done at the High Court level, and imagine that you have been successful and you are now in the Court of Appeal, you are part of the bench that has had the appeal, what would be your view or views as regards the findings of the High Court?
Thank you, Commissioner, my lady. I believe that in every legislation or a statute, there must be reasons behind or informing the enactment of that statute or the provisions contained therein. And looking at this, I will look at that. I will look at Section 13A of the Government Proceedings Act and ask myself, what were the purpose? What did the legislature intended? And I believe that the intention was actually to give a government department notice that, one, there is a suit that is going to be filed, or there is a claim that is pending against this department, the nature of the claim, and the date that the claim or cause of action arose. So the department would be able now to look at the documents and be able to prepare for it, whether to respond and maybe look at for ways of settling the dispute or disputing the dispute altogether. Now, that is the reason, in my view, why that section 13 was introduced. And it is very key to the administration of justice.
What about Section 21?
Now, Section 21 requires that before any execution is done, no, execution is actually a process of realizing one's fruit in a given judgment. And so it also talks of an access to justice. But now, balancing the interests of that individual, you need also to look at the aspect of where would this money come from before you execute. The government should be able to look for these funds if there is a judgment against it and an award has been made against it, so that if it is within its budgetary allocation, because remember, every ministry or every department of government has a budgetary allocation. And so this notice under Order 21 is important so that the government department can be able to budget and be able to allocate those funds without prejudicing or impacting negatively at the core service it is supposed to give to the public. That is my view.
So basically what you're saying is that you would overturn the High Court judgment.
I will look at it differently. If I had the jurisdiction to overturn it, I would...
No, you're now a judge of appeal.
Oh, I would definitely overturn it because of the public interest. Because at the end of the day, members of the public deserve to be served by their own government. And so, you don't want to have a situation where an ambulance, for example, which is outside waiting for in the hospital, is attacked by an auctioneer without notice. Okay. What will happen to the service that that ambulance is supposed to provide?
Okay, I hear you. So you are saying that you would say no, Section 13A, Section 21 of the Government Proceedings Act are there for very good reasons. Mm-hmm. Now, having declared, the judge having declared these provisions to be unconstitutional, and if you are in that position, for instance, would you be minded to look at other statutes, other regulations, other rules that also speak to the subject so that you just don't declare sections of the Government Proceedings Act unconstitutional and you leave other sections of the law that still speak to the same subject? Yes.
Thank you, Commissioner. When you look at the provisions of the civil procedure rules, any action or any step against the government is provided for. Like if there is a judgment in default, in the other cases you can simply apply for judgment in default and it is entered automatically. Judgment against the government, you have to seek leave. So what this one means is that you cannot declare one part of or one section of the civil procedure unconstitutional and leave the other parts. It will bring some inconsistency.
No, here is a situation where it is the Government Proceedings Act, sections of the Government Proceedings Act that have been declared unconstitutional, but as you rightly point out, you leave out the civil procedure because the matter is not before you.
Yes.
So do we then see as judges the folly of being rash in declaring provisions of a statute to be unconstitutional?
Commissioner, I think it is not, I will not call it rash, because at the end of the day, the judge the court that was making this decision was also looking at the aspect of access to justice. The only issue that perhaps we may have overlooked is because there is need to balance between access to justice.
But you very well explained to us why it was important.
Yeah, it is important, and you need to balance. This notice, this notice under 21 is important. Now, under Order 29, it provides ways in which you can actually enforce judgment against the government by getting a certificate of judgment, certificate of order against the government, serve it, then apply for the prerogative orders of mandamus. That will give the PS or the accounting officer a chance to come and explain why they are not honoring the judgment.
Yeah.
And if it is a question
I
of a budgetary
I agree
issue,
with you entirely,
Thank you.
but please, we have limited time.
Oh.
The next question that I was going to ask you is that now you've explained very well why it is important to give those notices. What other dangers do you see that are fraught with courts declaring statutes or parts of the statutes to be unconstitutional?
I don't know whether I've gotten the question clearly.
What are the dangers? One, of course, you said you must give them notice so that you do not attach an ambulance.
All right.
Yeah?
So the reasons why you need to exercise some caution in declaring a statute unconstitutional is the laguna that is likely to obtain upon declaration of that statute as unconstitutional. What I've seen in most cases is that sometimes a court can give a structural interdict by giving the offending
Okay,
person
so
time
one,
to-
you see that it's likely that there may be a gap or
Yes,
gaps in
yes.
operations of government. Any other?
Now, the interest of the public again may be prejudiced if that statute is declared unconstitutional without
So-
basis, because
Disruption of government functions and
Yes.
public services.
yes,
All right.
public good.
And public good. Finally, the last one. Are we likely to be accused of judicial overreach?
Of course, there is that perception that in the manner in which we, as courts sometimes, because we are the custodian of this Katiba, when the courts try to ensure that the rights of the citizens are realized, sometimes some sections of the society can see that the courts are overreaching, overstepping their mandate. But we have to be alive to the fact that this constitution captures the aspirations of the people of this country. And therefore, our duty is to protect and promote the values that are contained in this constitution.
Thank you, Judge. That's all from me, CJ.
Yes, good morning, Judge, again.
Good morning, Commissioner. AG.
Had you practiced criminal law before you joined the bench, or have you had occasion to attend to cases in the criminal division?
I practiced as a private practitioner. Usually, that is the common work that you begin with, particularly when you are beginning your practice. And I've also done criminal. I have practiced criminal law in the work that I do.
Yes.
Thank you.
Now, with the enhanced use of technology and development in technology, and also movement of people, where crime has become borderless, we find that most offenses that were created under the penal code were envisaged to be undertaken or committed in the physical world. However, now the crime scene has changed into the cyber world. Yet the penal code remains as it is. What are those traditional offenses that can be committed in the physical world and can also be committed in the cyber world?
Now, the What comes to my mind are crimes to do with property, like theft, you know. Somebody comes to your house and steals a goat, right? So that is physical, or steals your sheep, or steals whatever, physically, that property that belongs to you. But now, things have changed. People can now make use of technology to come and hit your account, hack your account without your knowledge. And so I think that is a sense in which the Cyber Crimes Act was enacted to address some of these challenges that has come as a result of the technological advancement.
Thank you. Let's develop that a bit. The crime of theft. The crime of theft is defined under the Penal Code, and one of the conditions or precedent definition of theft is that you must have had an intention to permanently deprive the person of the property or asset. Permanent deprivation. Taking that into account and having agreed that technology has influenced human life, we now have tangible assets. Do you understand the term tangible assets?
Yes.
Tangible assets are assets which are not physical.
Yes.
Can you give us a few examples of tangible assets? Of intangible assets, actually. Not tangible, intangible assets. Sorry.
I will look at it as in assets like you have property rights. Property rights in terms of what you hold, in terms of maybe shares, in terms of intellectual property rights, in terms of other things like that.
Thank you. You understand. So some of these intangible assets, some of them are purchased,
Yes.
some of them are created.
Yes.
Let us go to the ones which are purchased. Sometimes they can be limited, sometimes they can be unlimited. Supposing somebody steals intangible assets that is unlimited, and this person is charged with theft and is brought before you, how do we deal with the definition of theft that includes permanent deprivation? Taking into account that it might not necessarily happen within the borders of Kenya, it is borderless, and the time that it takes. How would